lecture today is legal ethics. If you have missed the previous lectures, the videos are available on Paul's and Rex Education Facebook page. So please don't forget to like and follow Rex Education and Philippine Association of Law School Facebook page so you can be updated with the dates and speakers for each lecture in the following weeks. And just a reminder, please, we strictly discourage the recording and reproduction of these lectures for personal gain, since if we want to replay this segment, we can do so. So please do not record this lecture. But again, we do encourage everyone to like and follow Rex Education and Paul's FB page, since the lectures will remain posted on those pages respectively. And please be attentive and be a place of comfort, since we will be having 3 hours of lecture. So, and also please comment or post your questions, as we will be having a question and answer segment later with Dean Grapilon. So now, without further ado, I have the honor and the privilege of introducing this afternoon our lecturer. He graduated from the Divine Word University with a degree in Bachelor of Arts, major in English and History as magna cum laude, and he attained his Bachelor of Laws from the University of the Philippines. He is attained likewise a diplomate in the industrial relations from the same university. He's also a master's candidate in public administration, industrial relations, and laws, again from the University of the Philippines. Certificates in the program for lawyers, Harvard University, Cambridge, Massachusetts. He's also a senior mediator of Supreme Court and the American Bar Association accreditation course. He's also a rotating chair, president of Law Association in Asia Pacific. He is until now an accredited domestic and international arbitrator at the Philippine Dispute Resolution Center and the Office of the Administrator for Dispute Resolution at the Department of Justice. He is currently the Dean of Philippine Law School, a lecturer, the mandatory continuing legal education program, and of course, a professor of law since 1996. He's likewise a founding partner in J.A. Grapilon Law Office. And lastly, he is the National Committee Chairman of the Committee on Alternative Dispute Resolution of the Integrated Bar of the Philippines, and also he's a senior partner commission on bar discipline of the Integrated Bar of the Philippines. Ladies and gentlemen, join me in welcoming Dean Jose Aguila Grapilon.
Thank you. Thank you, Justin. I have to give credit to my alma mater in my Master of Laws degree, which you forgot.
Yes,
I graduated from the Philippine, from the Pamantasan ng Luzon, Manila, for my Master of Laws. Anyway, I will start. Ready na? Yeah? Can we start now?
Yes, Dean, we can start now.
Okay. The lecture this afternoon will cover a lot of what Justice Hernando has penned as Justice of the Supreme Court on legal ethics. And we will have snippets of what the new code of professional responsibility and accountability is, what is there. But as we know, the syllabus will not include, of course, the latter subject which I was talking about. But in any case, since the lecture would involve legal ethics, legal and judicial ethics, I deemed it wise to at least suggest in some instances how the new code of professional accountability and responsibility will impinge on the previous code. So we start with the lawyer's oath. The lawyer's oath previously, if I may read, says that I do solemnly swear that I will maintain allegiance to the Republic of the Philippines. I will support the Constitution and obey the laws as well as the legal orders of any duly constituted authority. And I will do no falsehood nor consent to the doing of any in court. I will not wittingly or willingly promote or sue any groundless or false or unlawful suit or give aid nor consent to the same. I will delay no man for money or malice and will conduct myself as a lawyer according to the best of my knowledge and discretion with all good fidelity as well as to the courts as to my clients, and I impose upon myself these voluntary obligations without any mental reservations or purpose of evasion. So help me God. The new revised lawyer's oath, which I will read, says that I, the name of the new lawyer, do solemnly swear, or here you are given the option to affirm, not to take the oath, that I accept the honor, privilege, duty, and responsibility of practicing law in the Philippines as an officer of the court in the interest of our people. I declare fealty to the Constitution of the Republic of the Philippines. In doing so, I shall work towards promoting the rule of law and a regime of truth, justice, freedom, love, equality, and peace. I shall conscientiously and courageously work for justice, as well as safeguard the rights and meaningful freedoms of all persons, identities, and communities, and I shall ensure greater and equitable access to justice. I shall do no falsehood, nor shall I pervert the law to unjustly favor nor prejudice anyone. I shall faithfully discharge these duties and responsibilities to the best of my ability with integrity and utmost civility. I impose all this upon myself without mental reservation nor purpose of evasion. Here you are given the option either to take the to call on God, um, or omit the "So help me God" with just an affirmation. This year's bar passers will be sworn under the new lawyer's oath. The lawyer's oath will bind all lawyers as a source of obligation such that its violation is a ground for suspension, disbarment, or disciplinary proceedings. A member of the bar may be penalized, even disbarred or suspended from his office as an attorney for violating the lawyer's oath and for breaching the ethics of the legal profession. Um, a form of public trust, the performance of which is entrusted to those who are qualified and who possess good moral character. The appropriate penalty on an errant lawyer depends on the exercise of sound judicial discretion based on the surrounding facts, penned by Justice Hernando in Constantino versus Aranzazo Jr., administrative case number 9701, February 10, 2021. In Jimeno Jr. versus Jimeno, administrative case number 12012, July 2018, disciplinary proceedings against lawyers are designed to ensure that whoever is granted the privilege to practice law in this country should remain faithful to the lawyer's oath. What then is the practice of law? Before the amendment of the Code of Professional Responsibility, jurisprudence defines practice of law as any activity in or out of court which requires the application of law, legal procedures, knowledge, training, and experience. To engage in the practice of law is to perform those acts which are characteristics of the profession. Generally, to practice law is to give notice or render any kind of a service which device or service requires the use in any degree of legal knowledge or skill. Of course, you all know about Cayetano versus Monson. Notably, the practice of law is not limited to the conduct of cases in court. Under Section 1, Canon 3 of the Code of Professional Responsibility and Accountability, the new one, which took effect on May 29, 2023, and is retroactive in nature, the term practice of law is defined as follows. Under Section 1, practice of law is the rendition of legal service or performance of acts or the application of law, legal principle, and judgment in and out of court with regard to the circumstances or objectives of a person or a cause, and pursuant to a lawyer-client relationship, or other engagement governed by the CIPRA. It includes employment at the public service or private sector and requires membership in the Philippine bar as qualification. Generally, we know that the practice law is to give advice or render any kind of service that involves legal knowledge or skill. The practice of law is not limited to the conduct of cases in court. It includes legal advice and counsel and the preparation of legal instruments and contracts by which legal rights are secured, although such matter may or may not be pending in court. Case of ULIP versus Legal Clinic Incorporated. A lawyer-client relationship, emphasis on the lawyer-client relationship, begins from the moment a client seeks the lawyer's advice for a legal concern. Upon a legal concern, the seeking may be for consultation or transactions or other legal concerns, or for representation of the client in an actual case in court or other form. From the moment on, the lawyer is bound to respect the relationship and to maintain the trust and confidence of his client. Again, referring to Constantino versus Aranzazo Jr. In turn, you will find that under the CIPRA, it defines a lawyer-client relationship in this wise. Section 3 says that a lawyer, and I quote, a lawyer-client relationship is of the highest fiduciary character. As a trust relation, it is essential that the engagement is founded on the confidence reposed by the client on the lawyer. Therefore, a lawyer-client relationship shall arise when the client consciously, voluntarily, and in good faith vests a lawyer with the client's confidence for the purpose of rendering legal services such as providing legal advice or representation, and the lawyer, whether expressly or impliedly, agrees to render such service. What are the factors used to determine if one is engaging in the practice of law? The factors determinative of whether a particular activity constitutes practice of law, quote unquote, are as follows: habituality, compensation, application of law, principle, legal principle, practice or procedure, and the attorney-client relationship. The question is whether the practice of law is a right or a privilege. The practice of law is not a right, but a privilege bestowed by the state only on those who possess or continue to possess the qualifications required by law for the conferment of such privilege. The privilege may be taken away if one falls short of the requirements imposed by law, contained in AA Total Learning Center for Young Achievers Incorporated versus Carona, penned by Justice Hernando on March 10, 2020. Again, in Pitelo versus Rivera, penned again by Justice Fernando, October 16, 2019, the title of attorney is reserved to those who, having obtained the necessary degree in the study of law and successfully taken the bar examinations, have been admitted to the Integrated Bar of the Philippines and remain members thereof in good standing, and it is they only who are authorized to practice law in this jurisdiction. The practice of law is a privilege burdened with conditions and is reserved only for those who meet the twin standards of legal proficiency and morality. It is so delicately imbued with public interest that it is both a power and a duty of this court to control and regulate it in order to protect and promote the public welfare, quote unquote. Can the practice of law be delegated to any person? Again, in Pitelo versus Rivera, the court reminded the respondent lawyer that the practice of law is not a natural, absolute, or constitutional right to be granted to anyone who demands it. Rather, it is a high personal privilege limited to citizens of good moral character with special educational qualifications, duly ascertained and certified. Being a personal privilege, respondent cannot simply consent to anyone using the signature and other bar details. He did not have the authority to bestow license to anybody to practice because by doing so he usurped the right and authority that is exclusively vested upon this court. The authority to allow somebody to practice law and to closely scrutinize the fitness and qualifications of any law practitioner remains with this court, and respondent has no right whatsoever to exercise the same. To emphasize, the right to practice law is not a natural or constitutional right, but it is in the nature of a privilege or franchise. It is limited to persons of good moral character with special qualifications, again, duly ascertained and certified. The right does not only presuppose in its possessor integrity, legal standing, and attainment, but also the exercise of a special privilege, highly personal, and partaking of the nature of a public trust. In the previous CPR, the Code of Professional Responsibility, Canon 9 says, and I quote, a lawyer shall not directly or indirectly assist in the unauthorized practice of law. And Rule 9.01 says that the lawyer shall not delegate to any unqualified person the performance of any task which by law may only be performed by a member of the bar in good standing. In the new CIPRA, Section 35, and I may read, says that the non-delegable legal tasks a lawyer shall not delegate or permit any non-lawyer, including a paralegal, to A, accept cases on behalf of the lawyer, B, give legal advice or opinion, C, act independently without the lawyer's supervision or direction, D, to hold himself or herself as a lawyer or be named in association with the lawyer in any pleading or submission to any court, tribunal, or other government agency. E, appear in any court, tribunal, or other government agency or actively participate in formal legal proceedings on behalf of the client except when allowed by the law or rules. F is to conduct negotiations with third parties unless allowed in administrative agencies without the lawyer's supervision or direction. And H is G is to sign correspondence of containing a legal opinion, and H is perform any of the duties that only lawyers may undertake. These provisions, according to the CIPRA, shall not apply to law student practitioners under Rule 138-A of the Rules of Court. In describing law as a profession and not as a business or trade, Bihag versus ERA, which was an which is administrative case number 12880, November 23, 2021. The court took notice of Attorney ERA's exercising deceit and betrayal in his fiduciary duty towards his client when he took advantage of his superior knowledge of the law and filed two actions in behalf of Laneco, this is a corporation, when only one would have sufficed. As may be readily glanced from its fee structure, he charged separate engagement fees, appearance fees, and pre-success and success fees for each of the two cases. Obviously, his intention was to turn the engagement contract into a money-making venture. The principle that law advocacy is not capital that necessarily yields profits has been totally lost on attorney era. The act of soliciting cases constitutes malpractice. Section 27, Rule 12838 of the Rules of Court expressly provides that the practice of soliciting cases at law for the purpose of gain, either personally or through paid agents or brokers, constitutes malpractice. In the case of Religious Affairs versus Bio, the court, speaking through Justice Osaeta, declared that it is highly unethical for an attorney to advertise his talents or skill as a merchant advertises his wares. Law is a profession and not a trade. The lawyer degrades himself and his profession who stoops to and adopts the practices of mercantilism by advertising his services or offering them to the public. As a member of the bar, he defiles the temple of justice with mercenary activities, as the money changers of the old defiled the temple of Jehovah. The most worthy and effective advertisement possible, even for a young lawyer, is the establishment of a well-merited reputation for professional capacity or fidelity to trust. This cannot be forced, but must be the outcome of character and conduct. Citing in the same case, Tagorda, where the respondent lawyer was suspended from the practice of law for 1 month for advertising his services and soliciting work from the public by writing circular letters, the court reprimanded Attorney Bayot for having published an advertisement in the Sunday Tribune of June 13, 1943, which offers its legal assistance in securing marriage licenses. I would suppose this lawyer was following examples of in the United States, where lawyers could advertise their services. In the old CPR, Rule 2.03, a lawyer shall not do or permit to be done any act designed primarily to solicit business, legal business. Rule 2.04, a lawyer shall not charge rates lower than those customarily prescribed unless the circumstances so warrant. Rule 3.04 says that a lawyer shall not give or pay anything of value to representatives of the mass media in anticipation of or in return for publicity to attract legal business. Under the new CIPRA, Section 17 talks about non-solicitation and impermissible advertisement. A lawyer shall not directly or indirectly solicit or appear to solicit legal business. A lawyer shall not directly or indirectly advertise legal services or any platform or media except with the use of dignified, verifiable, and factual information, including biographical data, contact details, fields of practice, services offered, and the like, so as to allow a potential client to make an informed choice. In no case shall the permissible advertisement be self-laudatory. A lawyer, law firm, or any of their representatives shall not pay or give any benefit or consideration to any media practitioner, award-giving body, professional organization, or personality in anticipation of or in return for public publicity or recognition to attract legal representation or retainership. What are certain unethical acts of in legal in violation of the professional responsibility and legal ethics? The unethical acts of borrowing money from the client and accepting payment but not performing any work. Time and time again, the court has consistently held that deliberate failure to pay just debts constitutes gross misconduct for which a lawyer may be sanctioned with suspension from the practice of law. Lawyers are instruments for the administration of justice and vanguards of our legal system. They are expected to maintain not only legal proficiency but also high standard of morality, honesty, integrity, and fair dealing so that the people's faith and confidence in the judicial system is ensured. They must at all times faithfully perform their duties to society, to the bar, the courts, and their clients, which include prompt payment of financial obligations. Foster versus Agtang. In Buenaventura versus Gill, the court disbarred the respondent for borrowing money from his client by presenting his spurious title of the mortgage property, refusing to pay his debt despite demand, and issuing worthless checks, including failure to comply with the orders of the Integrated Bar of the Philippines. Again, in Reyes versus Rivera, the court likewise disbarred the respondent for misappropriating the funds of his client and misrepresenting that he filed a petition for declaration of nullity of marriage before the RTC when none was in fact filed. Respondent even simulated the stamp of the office of the clerk in court of the RTC to make it appear that it received the petition. In Brunet versus Guaren, respondent lawyer, despite having received a portion of his acceptance fee, neglected and failed to perform his obligation to file the case for the tithing of complainant's lot. Consequently, the court found him guilty of violation of the CPR, Canon 17, fidelity to the cause of his client, and 18, competence and diligence, and suspended him for a period of 6 months. In so ruling, the court stressed that the practice of law is not a business. It is a profession in which duty to public service, not money, is the primary consideration. Lawyering is not primarily meant to be a money-making venture, and law advocacy is not capital that necessarily yields profits. The gaining of a livelihood should be a secondary consideration. The duty to the public and to the public service and to the administration of justice should be the primary consideration of lawyers who must subordinate their personal interest or what they owe to themselves. How is the legal profession distinguished from a mere business? The following are the characteristics which distinguishes the legal profession from a mere business, namely, first, it is the duty of public service, which the emolument is only a byproduct and in which one may attain the highest eminence without making much money. Second, a relation as an officer of the court, to the administration of justice involving thorough sincerity, integrity, and reliability. Third, a relation to the clients, in the highest degree of fiduciarity. And fourth, a relation to colleagues, at the bar characterized by candor, fairness, and unwillingness to resort to current business methods of advertising and encroachment on their practice or dealing directly with their clients. This is the landmark case of Sisip Salazar Feliciano Hernandez and Castillo. In re Sisip Salazar Feliciano Hernandez and Castillo, GR number X92-1, July 30, 1979. What are the requirements for admission to the bar? The rules of court mandates that an applicant for admission to the bar must be a citizen of the Philippines, at least 21 years of age, of good moral character, and a resident of the Philippines. He must also produce before the court satisfactory evidence of good moral character and no charges against him involving moral turpitude. which have been filed or are pending in any court in the Philippines. Moreover, admission to the bar involves various phases such as furnishing satisfactory proof of educational and moral and other qualifications, passing the bar examinations, taking the lawyer's oath, and signing the roll of attorneys from and receiving from the clerk of court of the Supreme Court a certificate of the license to practice in Reda Kanay. Every applicant for admission to a member of the bar must, as we said already, citizen of the Philippines, resident, produce satisfactory evidence of good moral character, at least 21 years of age, no charges pending, moral turpitude, lawyer's oath. Then you have passed the bar exam, complied with the academic requirements, earned a bachelor's degree in arts and science, and signed the roll of attorneys. Under Rule 7.02, a lawyer shall not support the application for admission to the bar of any person known to him, by him, to be unqualified in respect to character, education, or other relevant attribute. Under Administrative Matter number 19.03-23, in re-amendment of Section 5, Rule 138, in relation to the revision of the Rule 138-A of the Rules of Court, it says that no applicant who obtained the Bachelor of Laws degree shall be admitted to the bar examination unless he or she satisfactorily completed the following course in a law or university duly recognized by the government. So you have there the enumeration of the different subjects: civil law, commercial law, etc. Rule 7.01 cites and states that the lawyer shall be answerable for knowingly making a false statement or suppressing a material fact in connection with his application for admission to the bar. Can a Filipino citizen who graduated from a foreign law school be admitted to the Philippine bar? In bar matter number 1153, the court went on to suggest and announce that the Filipino citizen who graduated from a foreign law school shall be admitted to the bar examinations only upon submission to the Supreme Court of certification showing A, completion of all courses leading to the degree of Bachelor of Laws, B, recognition or accreditation of the law school by the proper authority, and C, completion of all the fourth-year subjects to the Bachelor of Laws academic program in a law school duly recognized by the Philippine government. Can a lawyer who loses his Philippine citizenship continue to engage in the practice of law here in the Philippines? The Constitution provides that the practice of all professions in the Philippines shall be limited to Filipino citizens, save in cases prescribed by law. Filipino citizens is a requirement for admission to the bar. The loss thereof terminates membership in the Philippine bar and consequently the privilege to engage in the practice of law. In other words, citizenship ipso iure terminates the privilege to practice law in the Philippines. The practice of law is a privilege denied to foreigners. The exception is when Filipino citizenship is lost by reason of naturalization as a citizen of another country, but subsequently reacquired and pursuant to Republic Act 9225 or the Citizenship Retention and Reacquisition Act of 2003. This is because, quote, all Philippine citizens who become citizens of another country shall be deemed not to have lost their Philippine citizenship under the conditions of that Republic Act 9225, close quote. Therefore, a Filipino lawyer who becomes a citizen of another country is deemed never to have lost his Philippine citizenship if he reacquires it in accordance with Republic Act 9225, although he is also deemed never to have terminated his membership in the Philippine bar. No automatic right to resume law practice accrues. This is in red Dakanay. What are the conditions then before a lawyer who reacquires his citizenship pursuant to Republic Act 9225 resume his practice of law? The lawyer who reacquires his Philippine citizenship based on Republic Act 9225 can resume his law practice by securing from the Supreme Court the authority to do so conditioned on the following. Number one, the updating and payment in full of his annual membership dues in the IBP. Number two, the payment of professional tax. Number three, the completion of at least 36 credit units of mandatory continuing legal education. This is especially significant to refresh the applicant's petitioner's knowledge of Philippine laws and update him of legal developments. And fourth, the retaking of the lawyer's oath, which will not only remind him of his duties and responsibilities as a lawyer and as an officer of the court, but also renew his pledge to maintain allegiance to the Republic of the Philippines, still in Reda Canay. What are the continuing requirements for membership of the bar? The following are the continuing requirements for membership of the bar. You have citizenship requirement under Section 14, subsection 2, Article 12 of the 1987 Constitution. Possession of moral character, exemplified and enunciated in Tan versus Elsa Bandal. And third is membership in the Integrated Bar of the Philippines in good standing, which means the payment of all dues and the certification by the IBP that he has no pending case in either in the Commission on Bar Discipline or in the Supreme Court. Fourth is compliance with the mandatory continuing legal education program and requirements on the payment of the professional tax. What is the purpose of the requirement of good moral character? In Dantes versus Dantes, the court said, and I quote, "It should be noted that the requirement of good moral character has four ostensible purposes, namely, one, to protect the public, two, to protect the public image of lawyers, third is to protect prospective clients, and fourth, to protect errant lawyers from themselves." We then go to the definition, which has been time and again requested for a clear and distinctive definition of what is moral turpitude. I venture to research and found that in Jesus Paras versus Bailoses and in Soriano versus Dizon, these are the proper findings and quotes. Moral turpitude is defined as an act of baseness, vileness, or depravity in the private and social duties which a man owes his fellow men or society in general, contrary to the accepted and customary rule of right and duty between man and man, or conduct contrary to public to justice, honesty, modesty, or good morals, also found in Garcia versus De Vera. Examples of crimes involving moral turpitude are as follows. You have estafa, because the act is unquestionably against justice, honesty, and good morals, found in Ray Vinson. And second is violation of BP 22, for example, as issuance of worthless checks indicates a lack of personal honesty and good moral character. Third is falsification, found in Repactolin. Embezzlement, found in De Jesus versus Paras, where you have, together with it, forgery, robbery, swindling, which are crimes which denote moral turpitude and as a general, all crimes of which fraud is an element which is looked on as involving precisely moral turpitude. A lawyer may be removed or suspended on the ground, among others, conviction of a crime involving turpitude under Rule 27, Rule 138 of Section 27. In Soriano versus Dizon, conviction of a crime involving moral turpitude may relate not to the exercise of the profession, but certainly to their good moral character. Where their misconduct outside of their professional dealings is so gross as to show them morally unfit for their office and unworthy of the privileges conferred upon them by their license and the law, the court may be justified in suspending or removing them from office. What happens if the applicant deliberately fails to disclose that there are pending criminal cases against him or her? Under Rule 7.01 of the Code of Professional Responsibility, it cites the fact that the lawyer shall be answerable for knowingly making a false statement or suppressing a material fact in connection with his application for the admission to the bar. In Haron S. Melling, Bar Matter 1154, June 8, 2004, respondent's non-disclosure of the criminal cases filed against him makes him also answerable under the Code of Professional Responsibility, which states that the lawyer shall be answerable for knowingly making a false statement or suppressing a material fact in connection with his application for admission to the bar. The judiciary has no place for dishonest officers of the court. Similarly, the declaration and the application for the bar exams that he was single was a gross misrepresentation of a material fact in utter bad faith and violation of Rule 7.01. That false statement, if it had been known, would have disqualified him outright from taking the bar examinations, as it indubitably exhibits lack of good moral character in Leda versus Tabang. Can non-lawyers appear before the court? As a rule, only members of the bar are allowed to practice. Zeta versus Malinaw. To recall, in Pitelo versus Rivera, which we mentioned earlier, the court stressed that the practice of law is a personal privilege. A lawyer does not have the authority to bestow license to anybody to practice law, because by doing so, he usurped the right and authority that is exclusively vested upon the Supreme Court. Exceptions would be that's enumerated herein. So you have the law student practice rule. Pursuant to Rule 138 of the Rules of Court, 138-A, law students duly certified therein can engage in the practice of law in a limited capacity. The limited practice of law covers appearances, drafting and submission of pleadings and documents before trial and appellate courts and quasi-judicial and administrative bodies, assistance in mediation and other alternative modes of dispute resolution, legal counseling and advice, and such other activities that may be covered by the clinical legal education program of the law school. This is with reference to the law student practice rule, administrative matter number 19-03-24-SC, June 25, 2019. What are the respective duties of the law student practitioners, their supervising lawyers, as well as the law school? The duties of law student practitioners acting under certification: the law student practitioner shall observe the provisions of Section 24, Rule 130 of the Rules of Court. The duties of the law schools would be to develop and adopt a clinical legal education program through the Office of the Dean. And the duties of supervising lawyers will be to supervise such number of certified law student practitioners as far as possible, and to personally appear with the law student practitioner in all cases pending before the second level courts, and in all other cases the supervising lawyer determines that his or her presence is, if is required. Further, You will note that the duties of student practitioners will include being prohibited from using information acquired in one's capacity as a law student practitioner for personal or commercial gain, and perform the duties and responsibilities to the best of one's ability as a law student practitioner, strictly observe the canons of the Code of Professional Responsibility. For the law school, among others, the Office of the Dean should develop and establish at least one law clinic in each school, must endorse qualified students for certification, and as law student practitioners under the rules, such endorsements shall constitute a certification that the dean or authorized representative knows that the applicant is a student enrolled in the clinical legal education program and possesses the good moral character and has met the requirements of Section 3 of this rule. And the student, the Office of the Dean must ensure compliance by the law student practitioners and supervising lawyers with the Code of Professional Responsibility. For the supervising lawyers, among others, the supervising lawyers assume personal, professional responsibility for any work performed by the certified law student practitioner, must read, approve, and personally sign any pleadings, briefs, or other similar documents prepared by the certified law student practitioner prior to the filing thereof, and shall be prepared by the certified law student for execution by the eligible party. And lastly, to provide the level of supervision to be up to the certified law student practitioner required by these rules. Who are the persons required or authorized to appear for the government? Under Section 33, Rule 138 of the Rules of Court, any official or other person appointed or designated in accordance with law to appear for the government of the Philippines shall have all the rights and duties authorized as an authorized member of the bar to appear in any case in which said government has an interest, whether direct or indirect. This means that duly authorized officials, even if they are not members of the bar, have the authority to sue on behalf of and by the principals to the judgment of any disposition of a competent court in the same manner and capacity as those who are actual members of the bar. In Villa Gomez versus People, such category of legal representation is part of the performance of official acts as mandated by law. Pro se or personal appearance. In civil cases before the MTC, a party may conduct its litigation in person with the aid of an agent or friend appointed by him for the purpose. In any court, in any other court that is RTC, a party may conduct its litigation personally or by aid of an attorney, and his appearance must be either personal or by a duly authorized member of the bar. Notably, a non-lawyer conducting his own litigation is bound by the same rules in conducting the trial of his case. He cannot, after judgment, claim that he was not properly represented and ultimately claim that there is a mistrial. In places where there are no available lawyers, in criminal cases particularly, the rule is that an accused has an immutable right to be assisted by a member of the bar, which is a due process requirement. Thus, even if the judgment had become final and executory, it may still be recalled and the accused afforded the opportunity to be heard by himself and counsel. The case of spouses Telan versus Court of Appeals. However, in localities where such members of the bar are not available, the court may appoint any person resident of the province and of good repute for probity and ability to defend the accused. Section 7 of Rule 116. Administrative and quasi-judicial bodies, when expressly authorized by law under Section 2, Rule 8 of Resolution Number 38 Series of 2006, the Energy Regulatory Commission Rules of Practice and Procedure speaks of a party being representing himself or may be represented by an attorney. Any non-lawyer who satisfies the commission or the presiding officer that he or she possesses the expertise to render valuable service to a party and assist it in the presentation of matters before the commission may be allowed to appear on behalf of a party or parties. In the HLURB, it provides that the appearance of counsel or representative is optional. And under Section 11B of the HLURB Rules of Procedure, a non-lawyer who represents a party shall attach to the pleading a special power of attorney authorizing such person to file a case and affidavit duly executed by the party represented, stating that the reasons why such person was so authorized. In labor cases, a non-lawyer may appear subject to certain conditions, as we already know in labor law. A non-lawyer may represent the claimant also before a cadastral court under the Cadastral Act and Section 9 of the Cadastral Act, which is Republic Act 2259. Any person claiming any interest in any part of the lands, whether named in the notice or not, shall appear before the court by himself or by some person in his behalf, and shall file an answer or on or before the return day or within such further time as may be allowed by the court. What are the limitations on the appearance of non-lawyers before courts? Non-lawyer shall confine his or her work to non-adversarial contentions. In Robinson versus Villapuerte y Ranyola, the court said that non-lawyers should not undertake purely legal work such as the examination or cross-examination of witnesses in the presentation of evidence. The services of non-lawyers should not be habitually rendered, since that calling constitutes the practice of law which is reserved for members of the bar, and non-lawyers cannot collect attorney's fees. Very importantly, the permission for a non-member of the bar to represent or appear or defend in the said court on behalf of the party litigant does not by itself entitle the representative or to compensation for such representation. An attorney shall be entitled to have and recover from his client no more than a reasonable compensation for his services, and imports the existence of an attorney-client relationship as a condition for the recovery of attorney's fees. In the Philippine Association of Free Labor Unions versus Binalbagan Isabela Sugar Company Incorporated, the court said that such a relationship cannot exist unless the client's representative in court be a lawyer. Since respondent Moning is not one, he cannot establish an attorney-client relationship with Enrique Intila and Victorian Tinasas or with the PAFLU, and therefore he cannot collect or recover attorney's fees. In what proceedings are lawyers not allowed to appear? Under Section 415 of the Republic Act 7160 of the Local Government Code, the parties must appear in person without the assistance of the counsel. Thus, Section 415 says that in all katarungang pambansang barangay proceedings, the parties must appear in person without the assistance of counsel or representative, except for minors and incompetents who may be assisted by their next of kin who are not lawyers. Under Section 10, subsection C of the Rules on Pleadings and Practice Procedure before the National Commission on Indigenous Peoples in disputes involving indigenous cultural communities and indigenous peoples. The general rule is that lawyers are prohibited to appear for any party as counsel. However, as an exception, lawyers may appear provided that he or she is appearing in his or her capacity as a member of the Council of Elders or due to his or her obligation as a member of the IP, indigenous community, for the purpose of defending or prosecuting his or her case. In the small claims case, and the rule, a procedure for small claims, administrative matter number 08-8-7 Supreme Court. The citation is that Section 18, Rule 4 of the Rules on Expedited Procedure in the first level courts provides that no attorney shall appear on behalf of or represent the party at the hearing unless the attorney is the plaintiff or defendant. If the court determines that the party cannot properly present his or her claim or defense and needs assistance, the court may, in its discretion, allow another individual who is not an attorney to assist the party upon the latter's consent. Are there instances where a lawyer is not allowed, when the lawyer is not allowed to practice law? These are the enumerated instances. One, of course, obviously, suspended lawyers during the period of suspension and before the lifting of the suspension order are not authorized to practice law. Tan versus Gumba. Engaging in the practice of law according to Justice Hernando in Cancino versus Sideriosa during one suspension is a clear disrespect to the orders of the court. In doing so, the faith and confidence which the public has reposed upon the judicial system has been put at stake, as it gives the impression that the court's order is nothing but a mere scrap of paper with no teeth to bind the parties and the whole world. Lawyers, or second is that lawyers, public officials, so by express provision of law, are prohibited from engaging in the practice of the profession during their tenure to wit. You have the president, the vice president, cabinet members, and their deputies, governors and mayors, judges and officials or employees of superior courts, the Solicitor General, Assistant Solicitor General, State Solicitors, Assistant Solicitors, and other officials and employees of the OSG under Section 36, Rule 138. It prohibits judges and officials, employees of superior courts, or the Office of the Solicitor General from engaging in private practice or giving professional advice to clients under Section 35, certain attorneys not to practice. No judge or other official or employee of the superior courts or of the office of the Solicitor General shall engage in private practice as a member of the bar or give professional advice to clients. Among others who are not supposed to practice law under provisions of the law and etc., you have members of the Judicial and Bar Council, government prosecutors, except the isolated appearance as a private prosecutor for a case when the offended party is his relative authorized by the superior does not violate the rule which bars certain attorneys from practicing law. Case of People versus Villanueva. Ombudsman and his deputies will also prohibit the chairpersons and members of constitutional commissions and prohibition based on special law, including civil service officials or employees whose duties require them to devote their entire time at the disposal of the government. Under the prohibition on special law, Republic Act 6713 prohibits public officials and employees during their incumbency from engaging in private practice of their profession unless authorized by the Constitution or law, provided such practice will not conflict or tend to conflict with their official functions in Noriega versus Season. In this case, the respondent Securities and Exchange Commission hearing officer was charged with malpractice for allegedly violating the prohibition of government employees to practice their professions. Nonetheless, the court dismissed the disbarment complaint after finding that respondent's acceptance is an isolated case. Hence, it does not constitute the practice of law, more so since respondent did not derive any pecuniary gain from the appearance because respondent and defendants were close family friends. Lawyers, public officials with restrictions to practice law include civil service officers or employees, lawyers who are senators or members of the House of Representatives, Sangguniang members, except which according to Republic Act 7160, shall not appear as counsel before any court in any civil case wherein a local government unit or office, agency, or instrumentality of the government is the adverse party. Sangguniang members cannot appear as counsel in any criminal case in which an officer or employee of the national or local government is accused of an offense committed in relation to its office. And Sangguniang Bayan members cannot use property and personal of the government except when the Sangguniang member concerned is defending the interests of the government. Among lawyers or public officials with restrictions to practice law will include retired justices or judges and former government lawyers. I quote Section 1, Republic Act 9910 as amended by 1946. One of the conditions of their pension is that no retiring justice or judge of the aforementioned courts or his or her surviving spouse receiving the benefits of the Act during the time that he or she is receiving said pension shall appear before any court as counsel or in any government or any subdivision or instrumentality thereof in an adverse party. Adverse interest conflicts exist when where the matter in which the former government lawyer represents a client in private practice and is subsequently related to a matter that the lawyer dealt with while employed by the government, and the interests of the current and former are adverse. On the other hand, you will note that congruent interest representation conflicts are unique to government lawyers and apply primarily to former government lawyers. In congruent interest representation conflicts, the disqualification does not apply or does not really involve any conflict at all, as enunciated in PCGG versus Sandigan Bayan. Who are the lawyers then who are authorized to represent the government? The following are the persons authorized to represent the government, as we all know now. It's the Solicitor General, the Assistant Solicitor General, and state solicitors and trial attorneys, the state prosecutors or special counsels, the Department of Justice, the provincial and city prosecutors and their assistants, and other attorneys in other legal offices of the government. It will include also any person appointed or designated in accordance with law to appear for the government of the Philippines, who shall have all the rights of a duly authorized member of the bar to appear in any case in which said government has an interest, direct or indirect. Section 33 of Rule 138. Does the Supreme Court have jurisdiction over complaints filed against government lawyers? In Guevara Castel versus Trinidad, administrative case number 10294, July 12, 2022, The court en banc laid down the following guidelines in the filing and handling of complaints against government lawyers. Number one, all complaints against and which seek to discipline government lawyers in their respective capacities as members of the bar must be filed directly with the Supreme Court. Conversely, complaints which do not seek to discipline them as members of the bar shall be dismissed for lack of jurisdiction and referred to the ombudsman or concerned government agency for appropriate action. Number two, in connection with the preceding paragraph, the court must determine whether the concerned agency, the ombudsman, or the court has jurisdiction over the complaint against the government lawyer. In making such determination, the following must be considered. The Did the allegations of malfeasance touch upon the errant lawyer's continuing obligations under the Code of Professional Responsibility and or the lawyer's oath? To put it more simply, the primordial question to be asked in making the determination is this: do the allegations in the complaint, assuming them to be true, make the lawyer unfit to practice the profession? If the question in paragraph 2 yields a positive answer, the case properly lies before the court. It shall retain jurisdiction. This is so because the power to regulate the practice of law and discipline members of the bar belongs to the Supreme Court. Necessarily, proceedings to be had before this court should concern these and only these matters. This rule shall hold even if the complaint also contains allegations of administrative and or civil service rules violations. In such situations, however, the court shall limit its ruling only onto the matter of respondent's fitness as a lawyer. On the other hand, if the question in paragraph 2 yields a negative answer, the court, for lack of jurisdiction, shall dismiss the case and refer the same to the appropriate government agency or the ombudsman. If multiple complaints have been filed, the process shall be the same. In the event the results, in the event that there is, for example, a situation which we have said in the immediately preceding paragraph, which is paragraph 2b, results in a situation where one or more complaints have been filed, have been dismissed and referred to the appropriate government agency, and one or more complaints have been retained by the court, the cases shall proceed independently from one another. Again, going back, what are the duties and responsibilities of a lawyer? The duties are enumerated in the rules of court and the Code of Professional Responsibility, which has an acronym, DAD-ESCORT. DAD-ESCORT, which D is to defend the accused of a crime, regardless of his personal opinion. A, to maintain allegiance to the Republic of the Philippines and to support the Constitution and obey the laws. D is to never reject the cause of the defenseless or oppressed. And escort, E, is not to encourage and commence continuance of proceedings or delay any man's cause from any corrupt motive or interest. S, to preserve the secrets of his clients. C, to counsel or maintain such actions or proceedings only as appears to him to be just, and such defenses only as he believes to be honestly debatable under the law. Escorts O, to obtain from all offensive personality and to advance no fact prejudicial to the honor or reputation of the party or witness. R is to observe and maintain respect due to the courts and judicial officers. And the last is T, to employ such means only as are consistent with truth and honor, and never seek to mislead the judge by an artifice or false statement of fact or law. The lawyer's duty to obey the laws and promote respect for the law and the legal processes, negatively put, demands that he shall not engage in unlawful, dishonest, immoral, or deceitful conduct, an act of lying or cheating. An immoral or deceitful conduct is one that involves a moral turpitude, and a lawyer who in, engages in such unlawful, dishonest, immoral, or deceitful conduct may be held administratively liable therefore. Needless to state, in Parts versus Vitorillo, the court said, and I quote, once admission to the bar is by no means a license to gloss over the loopholes in litigation, to hijack the legal process, or to manipulate the technical decisions of those unlearned in law. Among the sworn obligations of attorneys upon taking the lawyer's oath is to uphold the Constitution, obey the laws of the land at all times, and never to waver, even if vices of luxury, convenience, and worldly excesses tempt them to do so. Again, Justice Hernando, Parts, P-A-R-T-S-C-H versus Vitorillo, January 4, 2022. Violation of the notarial rules constitutes violation of Rule 1.01. In the realm of legal ethics, a breach of the aforesaid provision of the 2004 rules on notarial practice also constitutes a violation of the Code of Professional Responsibility. Pixon Hermoso versus Parado. Administrative case number 8116, September 16, 2020. Examples of unlawful, dishonest, immoral, or deceitful conduct. In Turla versus Karingal, it centered on falsely asserting that he had an exemption of an MCLE requirement. When Attorney Karingal indicated that he was MCLE exempt in the pleadings and motions he filed, although in fact he was not, he engaged in dishonest conduct which was also disrespectful of the courts. He undoubtedly placed his clients at risk, given that pleadings with such false information produce no legal effect and can result in the expunction of the same. Undeniably, Attorney Karingal did not stay true to the cause of his clients and actually violated his duty to serve his clients with competence and diligence. Again, we go back to issuance of the worthless check in Andaya versus Tomanda, engaging in law practice during suspension, in Cancino versus Seriosa, and in Kainer versus Amores, violation of rules on notarial practice, where, for example, the respondent notarized a document without the presence of the signatory and failed to indicate his commission number in the notarial certificate, and paying and manipulating the child victim to not attend the hearing in Piketty versus Paluna. To merit the ultimate penalty of disbarment, the conduct must be grossly immoral. In Arsiga versus Maniwa, and I quote, a lawyer may be disbarred for grossly immoral conduct or by reason of his conviction of a crime of involving moral turpitude, and a member of the bar should have moral integrity in addition to professional probity. Close quote. In Perez versus Katindig, the court went on to define immoral conduct and said that it involves acts that are willful, flagrant, or shameless, and that is slow and show a moral indifference to the opinion of the upright and respectable members of the community. Immoral conduct is gross when it is so corrupt as to constitute a criminal act, or so unprincipled as to be reprehensible to a high degree, or when committed under such scandalous or revolting circumstances as to shock the community's sense of decency. The court makes these distinctions as the supreme penalty of disbarment arising from conduct requires grossly immoral, not simply immoral conduct, as stated again in Phillips versus Kamindig. In Arsiga versus Maniwang, which we already cited, the court enumerated the following instances where a lawyer was disbarred for grossly immoral conduct. I'll read. Where lawyer Arturo P. Lopez succeeded in having carnal knowledge of Virginia C. Alvarez under promises of marriage, which he refused to fulfill, although they had already a marriage license and despite the birth of the child, in consequence of their sexual intercourse. He married another woman, and during Virginia's pregnancy, Lopez urged her to take pills to hasten the flow of her menstruation, and he tried to convince her to have an abortion, to which she did not agree. Constituted, according to the court, a particular case of grossly immoral conduct. Sarmiento versus Cui. In Cabrera versus Agustin, lawyer Francisco Agustin made Anita Cabrera believe that they were married before Leoncio B. Aglumat in the City Hall of Manila, and after such fake marriage, they cohabited and she later gave birth to their child. In Toledo versus Toledo, where lawyer Toledo abandoned his lawful wife and cohabited with another woman who had borne him a child. In Bolivar versus Simbol, the conduct of Abelardo Simbol in making a dupe of Concepcion Bolivar by living on her bounty and allowing her to spend for her schooling and other personal necessities, his schooling, while dangling before her the mirage of a marriage, marrying another girl as soon as he finishes studies, keeping his marriage secret while continuing to demand money from the complainant and trying to sponsor her and persuade her to resume their broken relationship after the latter's discovery of the perfidy of the lawyer are indicative of character not worthy of a member of the legal profession. In the case of Kingwa versus Puno, where Flora Kingwa, a public school teacher, was engaged to lawyer Armando Puno, was prevailed upon by him to have sexual congress with him inside the hotel by telling her that it was all right to have sexual intercourse, because anyway, they were going to get married. She used to give Puno money upon his request, and after she became pregnant and gave birth to the baby boy, Attorney Puno refused to marry her. In the case of lawyer Anisito Aspiras, Portel versus Aspiras, a married man misrepresenting that he was single and making a promise of marriage, succeeded in having sexual intercourse with Josefina Mortel. Aspiras faked a marriage between Josefina and his own son, Cesar Aspiras, wrote to Josefina, "You are alone in my life till the end of my years in this world. I will bring you along with me before the altar of matrimony. Through thick and thin, for better or for worse, life or death, my Josephine, you will always be the first, middle, and last in my life." In the case of Royong versus Oblena, where lawyer Ariston Oblena, having had adulterous relationships for 15 years with Brixia Angeles, a married woman separated from her husband, seduced her 18-year-old niece who became pregnant and begot a child. Under the new code of professional responsibility and accountability, if the misconduct is grossly inexcusable, shameful, or flagrantly unlawful, the same constitutes a serious offense that is punishable by disbarment, suspension from the practice of law for a period exceeding 6 months, revocation of the notarial commission, and disqualification as notary public for not less than 2 years, and a fine exceeding 100,000 pesos. Note under the new CIPRA is that the misconduct is grossly inexcusable, shameful, or flagrantly unlawful. The same constitutes a serious offense that is punishable by disbarment. Cohabitation per se is not immoral. In the case of Soberano versus Villanueva, the court said that intimacy between a man and a woman who are not married, especially in the light of the circumstances attending this case, is neither so corrupt as to constitute a criminal act, nor so unprincipled as to warrant disbarment or disciplinary action against the man as a member of the bar. Neither must we overlook, according to Supreme Court, the circumstances that, in view of the facts adverted to above and others revealed by the record, which for obvious reasons need not be set forth in this statement, it was rather difficult for respondent to marry complainant herein. Under Rule 102 of the Code of Professional Responsibility, it is a duty of members of the bar not to counsel illegal activities. A lawyer shall not counsel or abet activities aimed at defiance of the law or lessening confidence in the legal system. Example, in Verano versus Tayag, it adverts to allowing the witness to draft his own judicial affidavit without the supervision of a lawyer. Number two, selling real properties to aliens, despite the prohibition against foreign ownership of Philippine private lands. Repairing documents with illegal consideration. For example, you have pactum commissarium stipulations. It is a duty of a lawyer to encourage amicable settlement and prohibition against frivolous suits. The usual function of a lawyer is not only to conduct litigation, but to avoid it where possible by advising settlement or withholding suit. A lawyer should be a mediator for concord and a conciliator for compromise rather than an instigator of controversy and a predator of conflict. Well said, well put. Useful function of a lawyer is not only to conduct litigation, but to avoid, where possible, by advising settlement or withholding suit. A lawyer should be a mediator for concord, and a conciliator for compromise, rather than an instigator of controversy and a predator of conflict. Making legal services available. Canon 2 requires that legal services should not only be efficient but also should be made available and accessible to those who need them in a manner compatible with the ethics of the profession. In addition, a lawyer shall not reject the cause of the defenseless, even in those instances in which they may not for valid reasons accept the case. The lawyer shall not refuse to render legal advice to the person concerned, if only to the extent necessary to safeguard their rights. What are the instances when a lawyer may decline employment? In the following cases, the lawyer should decline professional employment. Number one, if there exists, obviously, a conflict of interest. Number two, if he or she is not in a position to carry out the work effectively or competently. Number three, if he or she or if his or her acceptance violate rules of the legal profession. Number four, if it involves advocacy in any matter upon the merits of which he has previously acted in a judicial capacity. ECGG versus Andigabayan and in Santiago versus Rafanan, in any matter in which he knows or has reason to believe that he may be an essential witness for the prospective client. Is solicitation of legal business prescribed? The solicitation of legal business is not altogether prescribed. However, for solicitation to be proper, it must be compatible with the dignity of the legal profession. If it is made in a modest and decorous manner, it would bring no injury to the lawyer and to the bar. Thus, the use of simple signs stating the name or names of the lawyers, the office, residences, and addresses at fields of practice, as well as the advertisements in legal periodicals bearing the same brief data are permissible. Even the use of calling cards is now acceptable. Publication in reputable law lists in a manner consistent with the standards of conduct imposed by the canon of brief biographical or informative data is likewise allowable. Case of Khan versus Simbilio. True, honest, fair, dignified, and object information on legal services. Canon 3 talks about a lawyer in making his legal services shall use only true, honest, fair, dignified, and objective information or statement of facts. A lawyer shall not use or permit the use of any false, fraudulent, misleading, deceptive, undignified, self-laudatory, or unfair statement or claim regarding his qualifications for legal services. In the choice of a firm name, or no false, misleading, or assumed name shall be used. The continued use of the name of a deceased partner is permissible, provided that the firm indicates in all its communication that the said partner is deceased. Where a partner accepts public office, he shall withdraw from the firm, and his name shall be dropped from the firm unless the law allows him to practice law currently. A lawyer, also under Rule 3.04, shall not pay or give anything of value to representatives of the mass media in anticipation for or in return of publicity to attract legal business. The duty to participate in and to keep abreast of legal developments. While a lawyer's task in contributing to the improvement of the legal system is not a matter of strict duty, it is a duty nevertheless to the lawyer, to the lawyer's sense of public responsibility, which nevertheless flows from that responsibility. The improvement of the legal system is cannot, however, be done in a vacuum. The lawyer must recognize that the law is a part of a vast social network, and whether he likes it or not, he has to interact with the rest of society. Thus, the need on the part of the lawyer to transcend the narrow limits of technical law. A lawyer must broaden out and continue to grow in knowledge and competence in order to be able to make the law socially responsive. And unless lawyers faithfully comply with Canon 5 of the Code of Professional Responsibility, he or she may not be able to completely and diligently discharge his or her duties as lawyers. Worse, the lawyer is susceptible to mistake. What about lawyers' relations with other lawyers? Membership in the bar imposes upon lawyers certain obligations to one another. These include observance of honorable, candid, and courteous dealings with other lawyers, and fidelity to known and recognized customs and practices of the bar that make the practice of a law profession. What is the rule on the lawyer's language? A lawyer's language, though forceful and emphatic, must always be dignified and respectful, befitting the dignity of the legal profession, and the use of intemperate and unkind ascriptions has no place in the dignity of judicial forum. Sample violations of Rule 801 of the Code of Professional Responsibility. One would be statements like, quote, complainant induced his clients to extort money, unquote, unquote, and is already lusting for attorney's fees. Case of Fortes versus Santos. Statement made, for example, in counter affidavits uh, that the client was known as a drug addict or a fraud and making insinuations that their marriage was a fixed marriage was pointless and uncalled for, and thus only showed the clear intention of Attorney Misa to humiliate and insult Rosalind, who was the adverse party in Parks versus Misa Jr. Another case in Celudo versus Finesa, where respondent called the complainant an Indian who fails to comply with his commitment and is deemed witted. In Fernandez versus Dino Jr., the language was ascribing discourteous and unsupported imputations not only against complainant and his counsel, but also against the IBP Board of Governors. What about the responsible use of social media? Under the Code of Professional Responsibility and Accountability, a lawyer shall uphold the dignity of the legal profession in all social media interactions in a manner that enhances the people's confidence in the legal system, as well as promote its responsible use. The online posts of lawyers should uphold the dignity of the legal profession and shield it from disrepute. Lawyers shall not knowingly or maliciously post, share, or upload false or unverified statements or commit any other act of disinformation. The lawyer is prohibited from disclosing privileged information through online posts, whether directly or indirectly, with an officer of the court, tribunal, or government agency to influence the latter's performance of official duties. It must be stressed that even before the effectivity of the Code of Professional Responsibility and Accountability, lawyers who committed misconduct via social media were still found guilty of violating the Code of Professional Responsibility, which is Rule 8.01, among others. In Belo Henares versus Guevara, responded in a series of Facebook posts insulted and verbally abused complainant, Dr. Belo Henares, calling her Becky Bello, quack doctor, and stating that she is out to get poetic justice. Respondent further posted, poetic was the Puwitic. Boycott Bello, flawless, reckless, Bilat essentials. In its ruling, the court reminded everyone that the freedom of speech and of expression, like all constitutional freedoms, has its own limits and is not absolute. It may not be availed of or to broadcast lies or half-truths, insult others, destroy their name or reputation, or bring them into disrepute. Accordingly, the court found respondent Guevara guilty of violating Rule 8.01, among others, and suspended him from the practice of law for a period of 1 year. In Velasco versus Kausing, respondent in his Facebook page made a defamatory post against the opposing party in nullity of marriage case. Worse, he directly messaged via Facebook the minor son of the opposing party and told him, "Huwag mong gayahin ang iyong ama." Worst, he shared pictures of complainant's petition in the nullity case, which was still pending before the court. In an attempt to avoid administrative liability, respondent cited Bible verses and argued that he was merely exercising his constitutional right to press freedom. In calling the complainant polygamous, criminal, dishonest, arrogant, disgusting, and a cheater in the subject post, the court found respondent guilty of violation of Canon Rule 8.01. The court elucidated that a lawyer is not allowed to divide his personality as an attorney at one time and as a mere citizen at another, regardless of whether the lawyer is representing his client in court, acting as a supposed spokesperson outside of it or merely practicing his right to press freedom as a journalist blogger, his duties to the society and his ethical obligations as a member of the bar remains unchanged. Administrative case number 13521, a resolution regarding dated January 4, 2022 in administrative matter number 21-12-05-April 18, 2023. The court disbarred Attorney Larry Gadon for his viral video clip where he repeatedly cussed and cussed, profane, misogynistic, sexist, and abusive remarks against journalist Raisa Robles. A lawyer shall not encroach upon the business of another. A lawyer should not steal the other lawyer's clients nor induce the latter to retain him by a promise of better service, good result, or reduced fees for his services. Nevertheless, neither should he disparage another, make comparisons, or publicize his talents as a means to feather his law practice. It is, however, the right of a lawyer, without fear or favor, to give advice to those seeking relief against unfaithful or neglectful counsel. He may properly accept employment to handle a matter which has been previously handled by another lawyer, provided that the other lawyer has been given notice by the client that his services has been terminated. To whom though lawyers owe their first duty, it is essential that lawyers bear in mind at all times that their first duty is not to their clients but rather to the courts. That they are above all officers of the court sworn to assist the courts in rendering justice to all and sundry, and only secondarily are they advocates of the exclusive interests of their clients. For this reason, he is required to swear to do no falsehood or consent to the doing of the same in any court. Chavez versus Viola. In Casareo versus De La Cruz, respondent failed to inform the Court of Appeals of the fact of his client's death within the period required under the rules. Worse, he filed an unauthorized pleading, the subject motion, and ostensibly made it appear that the client was still alive at the time of the filing. By his conduct, Attorney De La Cruz violated Canons 10, Rule 10.01 and 10.03. A lawyer shall not misuse the rules of procedure. Procedural rules are instruments in the speedy administration of justice. They should be used to achieve such end and not to derail it. Thus, the filing of a lawyer of multiple petitions regarding the same subject matter constitutes the abuse of the court's processes and improper conduct that tends to obstruct and degrade the administration of justice. In Chua versus De Castro, respondent through atrocious maneuvers successfully delayed the disposition of the case, causing injury and prejudice to complainant. In doing so, respondent violated his oath of office and the Code of Professional Responsibility. In Diaz versus Mandagan, the court stated that respondent as a member of the bar should have employed only such means as are consistent with the laws, legal processes, truth, and honor. Owing candor, fairness, and good faith to the court, she should have not prosecuted her patently frivolous and meritless complaint or instituted a clearly groundless action before the ombudsman. Being a member of the bar, respondent should have known better not to misuse legal processes to defeat the ends of justice. Observing and maintaining respect due to the courts. The Code of Professional Responsibility under Canon 11 states that a lawyer shall observe and maintain the respect due to the courts and to judicial officers and should insist on similar conduct by others. Rule 11.01 states that a lawyer shall appear in court properly attired. In the new CIPRA, a lawyer's attire shall be consistent with the dignity of the court, tribunal, or other government agencies with due respect to the person's sexual orientation, gender identity, and gender expression. Rule 11.01 of the Code of Professional Responsibilities states that a lawyer shall punctually appear at court hearings. 11.03 states that the lawyer shall abstain from scandalous, offensive, or menacing language or behavior before the court. And Rule 11.04 states that the lawyer shall not attribute to a judge motives not supported by the record of the case, nor anything about materiality to the case. Rule 1105 states that the lawyer shall submit grievances against the judge to the proper authorities only. What is the proper attire in court? In Office of the Court Administrator Circular number 150-2018, the appropriate office attire are as follows. Number one, skirts of office uniforms or casual office attire should be at least knee length, 1 inch above the knee may be allowed. 2, appropriate footwear shall mean closed formal shoes. However, mules, slingback shoes, and tip toes are allowed. In turn, the following attire are prohibited when performing official functions: glossy, transparent, or net-like blouse or shirt, sandals, sleeveless, strapless, or spaghetti strap blouse, tank tops, and worn as an undershirt, blouse with over-plunging necklines, collarless t-shirts for men, micro-mini skirts, sandals and step-ins exposing the toes, and rubber sandals, slippers, and bakya, sporting of unkempt hair as well as wearing of earrings and other body ornaments by male employees are not allowed according to the OPA circulars. A lawyer should respect the court and the judicial officer by appearing during the trial of the case punctually and in proper attire. Inexcusable absence from or repeated tardiness attending a pretrial or hearing may not only subject the lawyer to disciplinary action but also prejudice his client too. As a consequence, thereof may be non-suited, declared in default, or the judge liable ex parte. A lawyer shall not attribute improper motive to a judge. Attorneys should observe and maintain respect due to the courts of justice and judicial officers. Arguments, written or oral, should be gracious to both the courts and the opposing counsel and be of such words as may be properly addressed by one gentleman to another. Case of People versus Taneo. The duty of the bar to support the judge against unjust criticism does not, however, preclude the lawyer from filing administrative complaints against erring judges or from acting as counsel for clients who have legitimate grievances against them. However, Rule 11.05 of the Code of Professional Responsibility reminds us that a lawyer shall submit grievances against a judge to the proper authorities only, which means that they be filed with the Supreme Court, which has administrative supervision over all other courts and the power to discipline them. What about the lawyer's duty to assist the court in speedy and efficient administration of justice? Canon 12. A lawyer shall exert every effort and consider it his duty to assist in the speedy and efficient administration of justice. Rule 12.01 of Canon 12 states that a lawyer shall not appear for trial unless he has adequately prepared himself on the law and the facts of the case, the evidence he will adduce, and the order of its preference. He should also be ready with the original documents for comparison with the copies. Rule 12.02 states that a lawyer shall not file multiple actions arising from the same cause. When you talk about a lawyer being adequately prepared when it comes to court, Rule 12.01 provides that the lawyer shall not appear for trial unless he has adequately prepared himself on the law and the facts of the case, the evidence he will adduce, and the order of its preference. He should also be ready with the original documents or for comparison with the copies. In turn, Rule 18.01, 18.02, and 18.03 states that a lawyer shall not undertake a legal service which he knows or should know that he is not qualified to render. He or she shall not handle any legal matter without adequate preparation. He or she shall not neglect the legal matter entrusted to him or her unless the lawyer comes to court adequately prepared. The trial may be postponed, which would entail delay in the early disposition of the case. We all know this, but Justice Hernando in Villanueva versus Alintahan, June 8, 2020, pronounced, and I quote, that there is forum shopping when the elements of litis pendentia are present, or where a final judgment in one case will amount to res judicata in another. There are as follows. Number one, identity of parties, or at least such parties that represent the same interests in both actions. And B, identity of rights or causes of actions. And C, identity of reliefs sought. It is a well-settled rule that the essence of forum shopping is the filing of multiple suits involving the same parties for the same cause of action, either simultaneously or successively, for the purpose of obtaining a favorable judgment. It exists when, as a result of an adverse opinion in one forum, a party seeks a favorable opinion in another, or when he institutes two or more actions or proceedings grounded in the same cause of action to increase the chances of obtaining a favorable decision. An important factor in determining its existence is the vexation caused to the courts and the parties litigants by the filing of similar cases to claim substantially the same reliefs. Forum shopping exists where the documents of litis pendentia are present, or where a final judgment in one case will amount to res judicata in another. Simply put, the outcome in one case would necessarily have an effect in the other, since both cases share the same cause of action and involve the same parties, enunciated in Go versus Teruel. A lawyer shall not delay nor impede the execution of judgment. A lawyer should not file multiple actions arising from the same cause, seeking substantially the same relief as those that had already been disposed of in a final judgment. As an officer of the court, whose primary function is to assist the court administer imperial justice and impartial justice, a lawyer should use those rules for the purpose and not for its frustration. The purpose of the rule that the lawyer should not talk to a witness during recess is to avoid any suspicion that he is coaching the witness what to say during the resumption of the examination. What are the elements of subornation of perjury? There are certain well-defined and indispensable requisites that must be established in every case of alleged subornation of perjury before an accused person charged with the commission of this crime can be convicted. Every essential element constituting the crime of perjury must be established by competent testimony. The prosecution must show the nature of the proceedings in which the alleged perjury was committed, the court or offer in which or before whom the false oath was taken, that the witness was duly sworn, that the testimony was material and that false, and that the defendant knowingly and willfully procured another to swear falsely, and that the witness sovereign did testify under circumstances rendering him guilty of perjury. U.S. versus Baliena. The lawyer should also avoid impropriety that tends to influence the court. Canon 13, which includes Rule 13.01, 13.02, and 13.03, states that a lawyer shall rely upon the merits of his cause and refrain from any impropriety which tends to influence or gives the appearance of influencing the court. Rule 13.01 states that the lawyer shall not extend extraordinary attention or hospitality to or seek opportunity for cultivating familiarity with judges. A lawyer shall not make public statements in the media regarding a pending case tending to arouse public opinion for or against the party, and a lawyer shall not brook or invite interference by another branch or agency of the government in the normal course of judicial proceedings. What is the subjudice rule? A lawyer shall rely on the merits of his case and cause and refrain from making any impropriety which tends to influence or gives the appearance of influencing the court. Improper acts which give the appearance of influencing the courts, such as extending extraordinary attention or hospitality to judges, should be avoided. The subjudice rule restricts comments and disclosures pertaining to the judicial proceedings in order to avoid prejudicing the issue, influencing the court, or obstructing the administration of justice. A violation of the rule may render one liable for indirect contempt under Section 3, Rule 71 of the Rules of Court. And the open justice principle refers to the freedom to question the government being a protected right of long-standing tradition throughout our history and histories of other jurisdictions. There is no doubt that the fundamental freedom to criticize government necessarily includes the right to criticize the courts, their proceedings, and their decisions. Referring to the United States, since the drafting of the Constitution over 200 years ago, American judges have anticipated and sometimes even encouraged public scrutiny of themselves, if not the judiciary as a whole. This open justice principle, which is as fundamental to a democratic society as freedom of speech, has been accepted as a doctrine in several jurisdictions. It is justified on the ground that if the determination of justice cannot be hidden from the public, this will provide a safeguard against judicial arbitrariness or idiosyncrasy and the maintenance of the public's confidence in the courts and the administration of justice contained in Re Makasay. The right of the lawyer to comment on a pending litigation or to impugn the impartiality of a judge to decide is much circumscribed. The court in the pending litigation must be shielded from embarrassment and influence in its all-important duty of deciding the case. It must therefore insist on being permitted to dispose of its business in an orderly, free manner, free from outside interference, obstructive of its functions, and tending to embarrass the administration of justice. On the other hand, once the litigation is concluded, the judge who decided it is subject to the same criticism as any other public official. Being a matter of court record, which has been taken up at the hearing held publicly and settled in a decision already promulgated, said theory was open for public consumption and hence an allusion thereto or statement in order to justify said criticism is not actionable. Strevel versus Figueras. When does an attorney-client relationship exist or arise? In the case of Tolentino versus Mangapit, the lawyer-client relationship is established when a lawyer voluntarily entertains a consultation, regardless of the close relationship between the parties or the absence of a written contract or non-payment of legal fees. The attorney-client relationship continues until the lawyer's authority to represent the interests of the client is sooner revoked or withdrawn by the client. The primary task of a lawyer as an advocate is to represent a party litigant in court, either as counsel for the plaintiff or defendant, or as public prosecutor or defense counsel, except for a public prosecutor who cannot choose cases to prosecute. The private practitioner, as a rule, is not obligated to act as counsel for any person who may wish to become his client. The rule, however, is subject to limitations under Canon 14 of the Code of Professional Responsibility. Canon 14 says under Rule 1401 that the lawyer shall not decline to represent the person solely on account of the latter's sex, race, status of life, creed, or because of its own opinion regarding the guilt of said party. Rule 1402 states that the lawyer shall not decline except for serious and sufficient cause an appointment as counsel, de officio or as amicus curiae, or a request from the Integrated Bar of the Philippines or any of its chapters for rendition of free legal aid. Rule 1403 states that the lawyer may not refuse to accept representation of an indigent client unless A, he is not in a position to carry out the work competently or effectively. Second is, he labors under a conflict of interest between him and the prospective client or between a present client and a prospective client. Rule 14.04 says that the lawyer accepts the cost of the person unable to pay his fees shall observe the same standard of conduct governing his relations with paying clients. There are two reasons for the rule. First, the poor and the needy are the persons who, when in trouble, need most the services of a lawyer. And second, one of the objectives of the Integrated Bar of the Philippines is to make legal services fully available for those who need them. And the fulfillment of this objective requires the lawyer should not likely decline employment from the poor and the needy. Who is an indigent client? An indigent client is one whose gross income and that of his immediate family do not exceed an amount double the monthly minimum wage of an employee and who does not own real estate property with the fair market value stated in the current tax declaration of more than 300,000 pesos. An amicus curiae, on the other hand, is a friend of the court referring to an experienced and impartial attorney who may be invited to the court to help in the disposition of issues submitted to it. Canon 15. A lawyer shall observe candor, fairness, and loyalty in his dealings and transactions with his clients. Rule 15.01 states that the lawyer, in conferring with the prospective client, shall ascertain as soon as practicable whether the matter would involve a conflict or is shall forthwith inform the prospective client if there is another conflict with another client. Rule 1502 states that the lawyer shall be bound by the rule on privileged communication with respect to matters disclosed to him by a prospective client. Rule 1503 talks about a lawyer shall not represent conflicting interests except by written consent of all concerned given after a full disclosure of the facts. Rule 1504, a lawyer may, with the written consent of all concerned, act as mediator, conciliator, or arbitrator in settling disputes. The lawyer, again, should always ascertain whether there's a possible conflict of interest. It is the duty of a lawyer to disclose and explain to a prospective client all the circumstances of his relations to the parties and any interest in or in connection with the controversy, which in its honest judgment might influence the client in the selection of counsel. The disclosure is more for the protection of the lawyer than that of the client. If, for instance, a lawyer conceals the fact that the adverse party used to be his client, the new client might have a reason to suspect, in case of an unfavorable judgment, that the circumstances prevented him from the full discharge of his duty. A lawyer shall preserve the secrets of a prospective clients. Bigasper versus Gonzalez cites the case by mentioning the fact that matters disclosed by a prospective client to a lawyer are protected under the rule on privileged communication, even if the prospective client does not thereafter retain the lawyer or the latter declines the employment. The reason for this is to make the prospective client free to discuss whatever he wishes with the lawyer without fear that what he tells the lawyer will be divulged or used against him, or for the lawyer to be equally free to obtain information from the prospective client. In Sabitsana Jr. versus Vertige, the termination of an attorney-client relation provides no justification for a lawyer to represent an interest adverse to or in conflict with that of the former client on a matter involving confidential information which the lawyer acquired when he was counsel. The client's confidence, once reposed, should not be divested by mere expiration of professional employment. Justice Hernando, in the case of Parungao versus Licuanan, gave occasion to cite that a lawyer's duty to protect the interest and confidence of his client, together with the corollary obligation not to represent interest in conflict or inconsistent with the same, extends even beyond the end of his professional engagement with said client. The protection given to the client is perpetual and does not cease with the termination of the litigation, nor is it affected by the parties ceasing to employ the attorney and retaining another, or by any other change of relation between them. It even survives the death of the client. In Ang versus Parapao, we are told about the purpose of the attorney-client privilege, and it is a duty of an attorney to maintain inviolate the confidence and at every peril to himself or herself to preserve the secret of his client. The performance of such duty involves the application of rules of evidence and of professional ethics, both of which seek to safeguard the client's confidence. To adequately represent the client, a full disclosure of the facts by the client to the attorney is a must, unless the client knows that his attorney cannot be compelled to reveal what is told to him. He will suppress what he or she thinks to be unfavorable facts. If that happens, therefore, the legal advice will be useless, if not misleading. Lawsuits will be conducted along improper lines, and trials will be full of surprises. The purpose of the attorney-client privilege is to encourage client to make full disclosure to his or her attorney and to place unrestricted confidence in the attorney in matters affecting the client's rights or obligations. What are the factors that must be established for the rule on privileged communication between an attorney and his or her client to apply? The factors essential to establish the existence of the privilege are as follows. Number one, there exists an attorney-client relationship or a prospective attorney-client relationship, and it is by reason of its relationship that the client made the communications. Second, the client made the communication in confidence. And third, the legal advice must be sought from the attorney in his professional capacity. Case of Mercado versus Vitriol. Again, Justice Hernando Imparangao versus Buchanan made mention of Canon 21 of the Code of Professional Responsibility, which says that the lawyer shall preserve the confidence and secrets of his client even after the attorney-client relation is terminated. It is settled that the mere relation of attorney and client does not raise a presumption of confidentiality. Proof must be presented that the client intended the communication should be confidential. The exception to the rule on privilege is Rule 21.01, where a lawyer shall not reveal the confidences or secrets of his client except when authorized by the client after acquainting him of the consequences of its disclosure and when required by law, and lastly, when necessary to collect his fees or to defend himself, his employees or associates, or by judicial action. Who are the persons covered by attorney-client privilege? They are the lawyer, the client, the persons reasonably believed by the client to be licensed to engage in the practice of law, and fourth, third persons who by reason of their work have acquired information about the case being handled as such. For example, secretaries, stenographers, messengers, and agents. A lawyer, therefore, shall not represent conflicting interests. This test is whether or not in behalf of one client. It is the lawyer's duty to fight for an issue or claim, but it is his duty to oppose it for the other client. In brief, if he argues for one client, this argument will be opposed by him when he argues for the other client. The rule covers not only cases in which confidential communications have been confided, but also those in which no confidence has been bestowed or will be used. Also, there is a conflict of interest if the acceptance of the new retainer will require the attorney to perform an act which will injuriously affect his first client in any matter in which he represents him, and whether he will be called upon in his new relation to use against his first client any knowledge acquired through their connection. Another test of the inconsistency of interest is whether the acceptance of a new relation will prevent an attorney from full discharge of his duties of undivided fidelity and loyalty to his client, or invite suspicion of unfaithfulness or double dealing in the performance thereof. In Rule 1507, you have these rules on lawyer impressing upon his client compliance with the laws and principles of fairness, and the lawyer shall represent his client with zeal within the bounds of the law. What about influence peddling? In the case of Fajardo versus Alvarez, a lawyer that approaches a judge to try to gain influence and receive a favorable outcome for his or her client violates Canon 13 of the Code of Professional Responsibility. The act of influence peddling is highly immoral and has no place in the legal profession. In Jimenez versus Verano Jr., Sylvia Santos versus Judge Evelyn Isakaya Chua, the court saw fit to impose a 6-month suspension against the judge who likewise committed acts of influence pending when she solicited 100,000 pesos from complainant Santos when the latter asked for her health in the case of her friend Emerita Munoz, who had a pending case with the Supreme Court because responding judge was a former court attorney at the High Court. By implying that he can influence the Supreme Court justices to advocate for his cause, respondent trampled upon the integrity of the judicial system and eroded confidence in the judiciary. This gross disrespect of the judicial system shows that he is wanting in moral fiber and that he lacks integrity in his character. The acts of respondent constitute the height of arrogance and deceit. Nimlao Jr. versus Camacho. What is the prohibition on private individuals when dealing with public officials? In the Anti-Graft and Corrupt Practices Act, it shall be unlawful for any person having family or close personal relations with any public official to capitalize or exploit or take advantage of such family or close personal relation by directly or indirectly requesting or receiving any present, gift, material, or pecuniary advantage from any person having some business, transaction, application, or request or contract with the government in which the public official has to intervene. Family relations shall include the spouse or relatives by consanguinity or affinity in the third civil degree. The word close personal relation shall include close personal friendship, social and fraternal connections, and professional employment, all giving rise to intimacy, which assures free access to public officers. The highly fiduciary nature of an attorney-client relationship imposes upon the lawyer the duty to account for all the monies received by his or her client. A lawyer's failure to return upon demand the money he or she received from his client gives rise to the presumption that he or she has appropriated the same for his or her own use. Again, penned by Justice Hernando in Francia versus Sagario. Lawyers, either in person or through another, are prohibited from acquiring the properties and rights in litigation. The following persons cannot acquire by purchase, even at a public or judicial auction, either in person or through the mediation of another, includes justices, judges, prosecuting attorneys, clerks of court, of superior and inferior courts, and other officers connected with the administration of justice. The property and rights in litigation or levied upon in execution for the court within whose jurisdiction or territory they exercise their respective functions. This prohibition includes the act of acquiring by assignment and shall apply to lawyers with respect to the property and rights which may be the object of any litigation in which they may take part by virtue of their profession. The rational advance for prohibition is that public policy disallows transactions in view of the fiduciary relationship involved. For example, the relationship of trust and confidence, and the peculiar control exercised by these persons. It is founded on public policy because by virtue of his office, an attorney may easily take advantage of the credulity and ignorance of his client and unduly enrich himself at the expense of the client. For the prohibition to apply, the foregoing elements must be established. Attorney-client relationship, the property or interest of the client must be in litigation. The attorney takes part as counsel in the case. The attorney himself or through another purchases the property or interest during the pendency of the litigation. What is the rule with regards to mistakes committed by lawyers? As a general rule, a client is bound by the mistakes of his counsel, Velasquez versus Court of Appeals, only when the application of the general rule would result in serious injustice should an exception there to be called for. Exceptions you have, the court has previously allowed the relaxation of these rigid rules of procedure in order to serve substantial justice in considering, for example, matters of life, liberty, honor, or property, existence of special or compelling circumstances, the merits of the case, the cause not entirely attributable to the fault or negligence of the party favored by the suspension of the rules, the lack of any showing that the review sought is merely frivolous or dilatory and the other party will not be unduly prejudiced. In Mega Fishing versus Estate of Gonzales, again penned by Justice Servando. Justice Servando also in Portuguese versus Centro ruled that the court suspended respondent from the Prime Centro for 3 years because attorney Centro's unjustifiable negligence and abandonment of his client's cause violated the lawyer's oath as well as the code of professional responsibility. He casually set aside a legal matter that was entrusted to him, which deserved his full attention and diligence. He was grossly negligent of his duty as counsel and was manifestly disinterested in his client's cause. He must be reminded that as a lawyer, he is duty bound to serve his client with competence and to attend his client's cause with diligence, care, and devotion. This is because a lawyer owes fidelity to the client's cause and must always be mindful of the trust and confidence reposed on him. What is the doctrine of imputed knowledge as applied to lawyer-client's relationships? Under the doctrine of imputed knowledge, notice to the agent is deemed notice to the principal. De Leon versus Manufacturers Life Insurance Company. As applied to lawyer-client relationship, means that the knowledge of any fact that is acquired by a lawyer during the existence of the relationship and while acting within the scope of his authority is imputed to the client. The exceptions to the doctrine of imputed knowledge are as follows. Number one, if strict application might foster dangerous collusion to the detriment of justice. Number two, service of notice upon party instead of upon his attorneys ordered by the court. And three, notice of pre-trial is required to be served upon the parties with their respective lawyers. A lawyer shall charge only fair and reasonable fees, which is determined by the following factors: the time spent and extent of the service rendered or required, the novelty and difficulty of the questions involved, the importance of the subject matter, the skill demanded, the probability of losing other employment as a result of the acceptance of the preferred case, the customary charges for similar services and schedule of fees of the IBP chapter to which it belongs, the amount involved in the controversy and benefits resulting to the client from the service, the contingency or certainty of compensation, the character of the employment, whether occasion established, and the professional standing of the lawyer. Quantum merit literally means as much as he deserves. It's used as a basis for determining an attorney's professional fees in the absence of an express agreement. The recovery of attorney's fees on the basis of quantum merit is a device that prevents an unscrupulous client from running away with the fruits of the legal services and counsel without paying for it, and also avoids unjust enrichment on the part of the attorney himself. In Rosario Jr. versus de Guzman, the court said that the attorney must show that he's entitled to reasonable compensation for the effort in pursuing the client's cause, taking into account certain factors in fixing the amount of legal fees. In Traders Royal Bank Employees Union Independent versus National Labor Relations Commission, this court took occasion to distinguish between general retainer and special retainer. A general retainer, according to the court, or retaining fee, is the fee paid to a lawyer who's to secure his future services for general counsel for any ordinary problem that may arise in the routine business of the client and referred to him for legal action. The future services of a lawyer are secured and committed to the retaining client. For this, the client pays the lawyer a fixed retainer, which could be monthly or otherwise, depending upon their arrangement. The fees are paid whether or not there are cases referred to the lawyer. The reason for the remuneration is that the lawyer is deprived of the opportunity for rendering services for a fee to the opposing party or other parties. In fine, it is a compensation for lost opportunities. A special retainer is a fee for a specific case handled by or special services rendered by a lawyer for a client. A client may have several cases demanding special or individual attention. If for every case there is a separate and independent contract for attorney's fees, each fee is considered as special retainer. So we go to the suspension, disbarment, and discipline of lawyers. Disciplinary action in the case of RICO versus Salutan against lawyers are sui generis, neither purely civil nor purely criminal. They do not involve a trial of an action or a suit, but is rather an investigation by the court into the conduct of one of its officers. Not being intended to inflict punishment, it is in no sense a criminal prosecution, and accordingly, it also involves neither a plaintiff nor a prosecutor. It may be initiated by the court motu proprio. Public interest is its primary objective, and the real question for determination is whether or not the attorney is still fit, is a fit person to be allowed the privilege of practicing law as such. Hence, in the exercise of its disciplinary powers, the court merely calls upon a member of the bar to account for his actuations as an officer of the court, with the end in view of preserving the purity of the legal profession and the proper and honest administration of justice by purging the profession of members who by their misconduct have proven themselves no longer worthy to be entrusted with the duties and responsibilities pertaining to the office of an attorney. Such posture, there can be no occasion to speak of a complainant or a prosecution. The quantum of proof in administrative cases, we all know, is substantial evidence of the amount of relevant evidence which a reasonable mind might accept as adequate to a conclusion. In Cancino versus Sidariosa, disbarment is the most severe form of disciplinary action. Hence, it must be exercised with great caution. It must therefore be imposed only for serious reasons and in clear cases of misconduct affecting the standing and moral character of the lawyer as an officer of the court and member of the bar, Justice Hernando in Cancino. No double disbarment in our jurisdiction. The court does not impose double disbarment under Section 42 of Canon 6 of the new Code of Professional Responsibility and Accountability. It says that the penalty when the respondent has been previously disbarred. When the respondent has been previously disbarred and is subsequently found guilty of a new charge, the court may impose a fine or order the disbarred lawyer to return the money or property to the client when proper. If the new charge deserves the penalty of disbarment or suspension of the practice of law, it shall not be imposed, but the penalty shall be recorded in the personal file of the disbarred lawyer in the office of the bar confidant or other office designated for the purpose. In the event that the disbarred lawyer applies for judicial clemency, the penalty so recorded shall be considered in the resolution of the same. We already know the grounds for disbarment or suspension would include deceit, malpractice, gross misconduct in such office, grossly immoral conduct, conviction of a crime involving moral turpitude, violation of lawyer's oath, you have willful disobedience of any lawful order of its superior court, corruptly or willfully appearing as an attorney for a party to a case without authority to do so. And these are included also under the new CIPRA. In the notarial practice law, the notary public is prohibited from performing an notarial act. When are these cases? Under Section 2, Rule 4 of the Notarial Rules, a notary public shall not perform a notarial act outside his regular place of business. The exception is a notarial act may be performed at the request of the parties in the following sites within his territorial jurisdiction: public offices, convention halls, similar places where oaths may be administered, hospitals and other medical institutions, public function areas and hotels and similar areas for the signing of instruments, any place where a party to an instrument or document requiring is under jurisdiction. If a person, for example, involved is a signatory to the instrument, it is not in the notary's presence personally at the time of the notarization, and if, exception, the person involved as signatory to the instrument is not personally known to the notary but otherwise identified through competent evidence as defined by the rules. So we come to the last portion is judicial ethics. What are these sources? You have new code of judicial conduct of the judiciary. You have the code of judicial conduct, rules of court, constitution, judicial and bar council, administrative issuances of the Supreme Court, revised penal code. What qualities should the judge possess under the new code of judicial conduct? You have independence, integrity, impartiality, propriety, equality, and competence and diligence. So you have these particular sections regarding the qualities of a judge, and employees of the court have no business meeting with litigants or their representatives under any circumstance. By his own admissions, Judge Dinopol failed to observe these ethical standards. In this answer or comment, Judge Dinopol admitted that he talked with C on several occasions to discuss case number, etc. Judge Dinopol also admitted that C, in at least 2 instances, requested him to delay the resolution of the writ of possession. And we find that Judge Dinopol compromised not only his impartiality in handling the case, but also his independence and integrity as a judge. His actions, no doubt, diminished public confidence and public trust in him as a judge. His actions gave the public the legal arguments on the court the impression and appearance that he can be influenced by extraneous factors other than legal arguments and the court evidence in discharging his judicial function. In addition, we find that Judge Dinopol committed impropriety in talking with litigants outside court proceedings. The improper conduct was further aggravated by the fact that these conversations took place in the absence of the opposing litigants and opposing counsel in the case of C versus Dinopol. Judge was included in the president's narco list. Upon investigation, it was discovered that he would ask for money in exchange for acquittance. And this is the court ruling in the case of Office of the Court Administrator versus Judge Reyes. Judge is a visible representation of the law and justice. He should be beyond reproach and must conduct himself with the highest integrity. Even a suspicion of illegal activity or dealings concerning the judge loses the public's faith and confidence to the judiciary. The inclusion of respondent judge to the president's narco list is a cause for concern for the judiciary, more so when such allegations are supported by the affidavits of numerous persons and confirmed by the judicial audit and investigation conducted by the Office of the Court Administrator. Respondent judge denied the affidavits executed by numerous persons as being highly dubious and questionable. The information from the anonymous BJMP personnel saying that the responding judge used Norma as a bag woman is unverified and merely hearsay. However, such affidavits and reports cannot simply be brushed aside and for this court to turn a blind eye. While it may be considered as hearsay, such information and statements can be considered as substantial evidence. So you have under integrity, the court reprimanded the judge for improper social media posts, half-dressed pictures of exposing tattoo art in the office of the court administrator versus Atilio Jr. Responded judge disregarded the appearance of propriety or disregarded propriety itself required of her when she posted Friendster photos of herself wearing an off-shouldered suggested dress and made this available for public viewing. Lorenzana versus Austria. Here, we are not, according to the court, we are not also unaware that the respondent's act of posting her photos would seem harmless and inoffensive. And had this act been done by an ordinary member of the public, as the visible personification of law and justice, however, judges are held to a higher standard of conduct and must accordingly comport themselves. Regarding impartiality, you have the judge uh, here being disqualified because instead of withdrawing from the proceeding, disclosed on the records the basis of disqualification. If based on such disclosure, the parties and lawyers, independently of the judge's participation, all agree in writing that the reason for the inhibition of the judge is immaterial or unsubstantial, the judge may then participate in the proceeding. The agreement signed by all parties shall be incorporated in the record of the proceedings. A judge, the court in the subjudicial rule admonished the judge who discussed this case in his class, a case which is still pending before the court. Tormis versus Paredes, where the subjudicial rule restricts comments and disclosures pertaining to judicial proceedings in order to avoid prejudging the issue, influencing the court, or obstructing the administration of justice. Notably, when Judge Paredes discussed the marriage scams involving Judge Torres in 2010, the investigation relative to the said case had not yet been concluded. In fact, that decision on the case was promulgated by the court only on April 2, 2013. 2020, he still could not make comments on the administrative case to prevent any undue influence in its resolution. Commenting on the marriage scams, where Judge Tormes was one of the judges involved, was in contravention of the subjudicial rule. A judge must not only be impartial, he must also appear to be impartial at all times. The acts of Judge Clapis in meeting Gakad, a litigant in the case pending before his sala, and telling her, sige kayo ako at mahalaga mo, ayusin ito, favored Gakad, constituting gross misconduct, and it is being in constant scrutiny by the public. His language, both written and spoken, must be guarded and measured lest the best of intentions be misconstrued. Needless to state, any gross misconduct seriously undermines the faith and confidence of the people in the judiciary. Gakad versus Clapis. Allowing a judge to inhibit without concrete proof of personal interest or any showing that his bias stems from an extrajudicial source will open the floodgates to abuse. Chavez versus Marcos, where the court said that whether or not to voluntarily inhibit from hearing a case is a matter within the judge's discretion, absent clear and convincing evidence to overcome the presumption that the judge will dispense justice in accordance with law and evidence. This court will not interfere. Thus, since the second paragraph of Rule 137, Section 1 was introduced, the court has periodically repeated that it shall always presume that the judge will decide the case on the merits of the case without bias. Allowing a judge to inhibit without concrete proof of personal interest or any showing that his bias stems from an extrajudicial source will open the floodgates to abuse. So, among others, you have boasting of his fraternal ties with the executive department and his disclosure that he has been a judge for the past 20 years. His complaint protest because his son did not qualify as a member of the national team in the swimming competition constitute vulgar and unbecoming conduct of a judge. In the case of Velasco versus Cordero, um, Judges Cordero Jr.'s disclosure that he's a judge that has been with the judiciary for the past 20 years, coupled with including his title as a judge at the end of his letter, does not automatically render him administratively liable. The circumstances of the instant case do not show that he used his judicial position to advance private interests. Nevertheless, for failing to be more circumspect in his choice of words, or for boasting of his alleged fraternal ties with the executive department, this court finds Judge Cordero Jr. guilty of unbecoming conduct. Competence and diligence of a judge, it is indispensable. The judges should act within the prescribed period to prevent delay in the administration of justice. In the case of the court administrator versus Teves, the rules prescribing the time within which certain acts must be done are indispensable to prevent needless delays in the orderly and speedy disposition of cases. Thus, the 90-day period is mandatory, which Judge Teves Sr. violated and caused undue delay. Discipline and administrative jurisdiction over members of the judiciary shall only be with the Supreme Court and only with the High Court. What is the effect, death, retirement, separation from service when there are proceedings for the disciplinary action against judges? Circumstances supervening only during the pendency of the proceedings and circumstances already existent prior to the institution of the proceedings. These are the rules. Disciplinary proceedings may not be instituted against a member, official, employee, or person of the judiciary who has already died, retired, or otherwise separated from the service. If such proceedings have been instituted notwithstanding the foregoing circumstances, the administrative case against a member, official, employee, or person shall be dismissed. However, once disciplinary proceedings have already been instituted, the respondent's supervening retirement or separation from service shall not preclude or affect the continuation of the same, provided that the supervening death of the respondent during the pendency of such proceedings shall result in the dismissal of the administrative case against him or her. How are the penalties imposed by the courts? The penalties would be you have administrative charges are classified as serious, least serious, or light. So how are they finally imposed? If one or more aggravating circumstances and no mitigating circumstances are present, the Supreme Court may impose the penalties of suspension or fine for a period or amount not exceeding double or maximum period under this rule. If one or more mitigating circumstances and no aggravating circumstances are present, the Supreme Court may impose the penalties of suspension or fine for a period or amount not less than half the minimum prescribed under this rule. If there are both aggravating and mitigating circumstances present, the Supreme Court may offset the other. That complies with the time allotted to me, and that ends the lecture. And I submit to the organizers and whatever might be utilized in the next 9 minutes.
Thank you so much po, Dean, for that comprehensive and informative lecture about legal ethics. We're so honored to have you this afternoon po. So we'll be having just a few questions The first question that was commented for us or that was posted was Dean. The question is, can a lawyer decline to be assigned as an ex officio lawyer? What are the instances when declining is allowed, if any?
Well, and usually the judge sometimes assigns lawyers present during courtroom trial as as official lawyer, but still the rules on which we have enumerated on declining cases still applies. Preeminently, you have, for example, it will result in the conflict of interest. Secondly, if the lawyer thinks that he's not competent enough, or adequately prepared for the case itself, and reasons which may be justified in the sense that being an ex officio lawyer, the lawyer himself herself should know that in participating, for example, in the case by acting as an ex officio lawyer, he should give his full attention, devotion, and competence to the case itself. Otherwise, he may be subject to disciplinary action himself.
Yes,
Person.
that's right. Yes, thank you so much, Dean. And before we proceed, we encourage everyone to still post or comment if you have any questions for Dean Grapilon. The second question po, Dean, is how do you report a person who is pretending to be a lawyer?
Oh, the even the Integrated Bar of the Philippines has this committee on uh, unauthorized practice of law. Unauthorized practice of law. Your recourse would be to get the attention of the Integrated Bar. You have chapters all over the country, or you can directly inform the Supreme Court. But certainly, the Supreme Court will. I'm sure the Supreme Court will delegate the Integrated Bar of the Philippines to its chapters to determine whether there is an authorized practice of law in that particular jurisdiction. Yes.
Thank you so much po, Dean. And another question would be, Dean, is the disciplinary action under the CPR exclusive or not? Is, for example daw po, delicadeza, a legal ground for disciplinary action too?
I don't really get the entire context by which the question is addressed. But anyway, I'll try to respond. I'll try to field the question by saying that, well, delicadeza, as always, is very important, but it's sometimes too ambiguous situation to really concretize it in the sense that delicadeza should be part and parcel of the whole disciplinary action. The whole ambit, for example, the gamut of, lawyers' actions would be such that sometimes delicadeza is relegated to, I say, a dark corner of determining whether indeed disciplinary action should proceed. Yes.
Yeah, okay. Thank you so much po, Dean. Dean, before we end our program, do you have any closing remarks for our viewers and for the bar reviewees?
Well, the Philippine Association of Law Schools, through its president, Dean Festin, has been undertaking this very laudable, more than laudable and worthwhile project, which to those who are interested enough may perhaps help them in trying to understand, for example, or as aptly described, the proper selected points to be taken up by in the bar examinations. Secondly, wishing the bar examinees the best of luck as usual, and we would certainly welcome, as a former president of the bar, I will welcome you to the brotherhood and sisterhood of the profession, and coping with, for example, the very stringent requirements of the code of professional responsibility and accountability will certainly be a challenge to new lawyers and also to senior lawyers like us. Thank you.
Thank you so much. Thank you so much, Dean, for having this lecture this afternoon. We are privileged to have you po. And so before we end this lecture, we have an upcoming schedule. So we'll have remedial law, special procedure by Dean Gemelito Festin. It's on Thursday, 2 p.m. And also we'll be having political law by Dean Ralph A. Sarmiento on September 8th, Friday, also 2 p.m. And again, we'd like to thank our sponsors. In a way of thanking and appreciating them, of course, is please again follow and like the page of Rex Education and Philippine Association of Law Schools to be updated for the upcoming lectures. Again, thank you so much, Dean Jose Aguila Grapilon for this wonderful lecture. And thank you, viewers, for having this afternoon, for freeing this afternoon in your schedule. Again, thank you so much. And again, in behalf of Rex Education and of Philippine Law Schools, we would like to thank you. Good
Thank you.
afternoon and
Bye-bye.
goodbye. See you next
Bye-bye.
lecture. Thank
See you
you
next
po.
time. Thank you. Thank you. Welcome.